Rules for adoption in India. Who is eligible to adopt a child in India? Any Indian citizen who is at least 18 years of age and has been declared eligible to adopt by the court can adopt a child in India. Additionally, married couples must adopt jointly. The legal framework for adoption in India is primarily governed by the Juvenile Justice, Care and Protection of Children, Act, 2015 and the Guidelines Governing Adoption of Children, 2015. What is the legal process for adoption in India? The legal process for adoption in India involves filing an application with the court or the authorized adoption agency. The adoption agency conducts a home study and prepares a report. After the report is submitted, the court or the agency matches the child with the prospective adoptive parents. The court then grants legal custody of the child to the adoptive parents, and the adoption is finalized through a court order. Are there any restrictions on the adoption of a child in India? Yes, there are restrictions on the adoption of a child in India. A child can only be adopted if he or she is an orphan, abandoned, or surrendered. Additionally, a child can only be adopted by Indian citizens or foreigners of Indian origin who are resident in India. The adoption must also comply with the provisions of the Hague Convention on Protection of Children and Cooperation in Respect of Inter-Country Adoption, 1993, which India has ratified. What are the post-adoption requirements in India? After the adoption is finalized, the adoptive parents must register the adoption with the authorities and obtain a new birth certificate for the child. The adoption agency or the court also conducts follow-up visits to ensure that the child is well cared for and the adoption is successful.